So good morning, everybody, and welcome to the most recent in the series of hidden risks in construction contracts, and specifically in relation to Qatar. My name's Symms. I'm the head of construction, and I'm joined today by two of my colleagues in relation to Qatar specifically. Khushboo, Shahdadpuri, who is based in Qatar normally, but is currently in Dubai, as you can see, although we are a little bit concerned that there may be some window cleaner coming past Khushboo's window shortly, and Aiman, who's with me here in Qatar today. So the format of today is very typical and to those that we've had previously, and I'll just share the screen. You may have to forgive me in relation to my own ability to do this. It's a fairly typical 1 hour session. Bear with me. And the issues that we're going to be dealing with today are those of damages and limits on liability, which I'll be speaking to, defects and limitation periods, which Khushboo will be dealing with, and then Aiman will be dealing with the recent Qatar compensation scheme, specifically in relation to COVID and the minimum wage law. Obviously, there's a session at the end, which is questions and answers. And of course, if you do have any questions during the course of the presentations, then please put them in the chat box and we'll endeavour to deal with those at the end of the session. So I'll move on then to the first one, damages and limits on liability. The purpose or style that we tend to adopt in these presentations is one of compare contrast. It's always very useful, I find, with my clients coming from different jurisdictions and legal disciplines to have a sense of, well, what is the baseline position? And normally, certainly in terms of the contracts that we deal with, a useful starting position is that of the common law, and specifically English common law, and then seeing how that compares with the position in the other jurisdiction, and in this case, in relation to Qatar. So as just a general point, and obviously then linking it into the FIDIC documents, which I'm sure most of you are familiar with, whatever legal system you're dealing with, there's going to be some sort of contractual damages concept. And invariably, that's always going to be related to the general law regarding damages. But then also you will have express clauses in your contract. Certain jurisdictions will also allow for implied terms. And invariably, in any contract, there is the prospect of a restriction on either the nature or the value of the damages that you're able to recover. And obviously, that is reflected within the FIDIC suite of documents, which actually really do deal with damages in a very common law type of way. And one of the first points that I make there on that slide is the concept of indemnity, which many people, I think, who aren't common law trained just tend to assume is nothing more than an entitlement to damages in contract. But it has a very, very specific meaning in the English common law. And the indemnities do have a wider ability to recover monies which might not be recoverable under normal damages. I won't go on into that in any more detail, but I pick up on it later, which is to say, beware the word indemnity, because it could well mean more than you really anticipate. So then there's the typical damages for breach of contract, and I make the point there of distinguishing between what is a cost and what is a loss. A cost is something that you end up having to pay out. A loss is something which you don't have the opportunity to earn. They're often confused, but it is a useful tool to distinguish between the two. And then the two specific clauses, which I'll touch upon later in the presentation, are liquidated damages, clause 8.8 of the FIDIC Red Book, where liquidated damages for delay are an exclusive remedy for delay, except in circumstances of termination. And then limits on recovery. There is a very well-known clause, clause 17.6 of the FIDIC Red Book, which I'll deal with in a little bit of detail, which looks to then achieve, for the benefit of both parties, specific limits are both by way of the types of damage that can be recovered and the cap, financial cap on liability. So, and then for those of you who have got a common law background, I anticipate that most of this is fairly familiar to you, but a very famous case from almost 200 years ago, Hadley and Baxendale, has two limbs, damages which arise naturally from the breach and damages which may be supposed to be in the contemplation of the parties at the time they made the contract. Now, one of the things is, of course, that this Hadley and Baxendale, the two rules, don't actually deal with the concepts of direct and indirect, although that's how they're often seen. The first limb is direct, the second limb is indirect, or what is consequential or not. And again, the first limb is often thought as non-consequential and the second limb consequential, but that's wrong. The test is what the Hadley and Baxendale test says. And that was emphasized in these two cases. I was involved in the second of the two. Oh, sorry, the first one, the McCain matter, which is both in the English High Court. And that is where there was a clause which certainly the contractor thought was going to protect it from indirect or consequential losses, particularly in relation to I remember it with the Hilton case. This related to hotel minibars. Where the minibars didn't work and Hilton claimed against the contractor for the loss of profit on the drinks in the minibars, and the contractor pointed to this clause, but in fact the court said no, actually this damage that's been incurred may reasonably be supposed to have been in the contemplation of both of the parties at the time they made the contract, and therefore it's recoverable. Liquidated damages for delay. There's a case that's been in the Supreme Court in England just in the last year called Triple Point. Lots of detail there, but basically it's saying that if you've got liquidated damages clause, generally speaking, if an employer then terminates the contract, then the liquidated damages will be recoverable up to the date of termination, and then after termination, it won't be liquidated damages. You'll have to prove what your damages are post termination. And then I make the point there about performance liquidated damages, often confused with delay liquidated damages, but they are very often in process and energy contracts where there is an attempt to establish in advance what the employer's remedies will be if the particular facility doesn't produce quite what it was supposed to produce. And then finally, irrecoverable damages. There's another famous case to do with a swimming pool called Ruxley Electronics, where the owner of the swimming pool wanted it completely rebuilt, even though it was just shallow by a few inches or so. And the court turned around and said, no, you can't have that. We're only going to give you the damages for the loss of enjoyment. So how then does that tie in with the Qatar? Well, although it's a codified system, actually the two articles are effectively saying something very, very similar, but it's expressed slightly differently. So actual loss that is incurred and loss of profit, as long as it is a natural consequence of the breach. And the second limb is this question of foreseeability. So relating to the often considered question of profits, lost profits would be recoverable under Qatar law insofar as they are foreseeable and direct. Another point, and then this links to what I've just said about the common law position relating to the Ruxley Electronics matter. Effectively, if you've got defective works, there is a concept in Qatar law of specific performance. By that I mean requiring the contractor to actually do what it was that they contracted to do, which in some circumstances could actually mean stripping out what has been built and putting back in what was supposed to be built. However, Article 245.2 does make it clear that if that remedy would be unduly onerous, then it won't be ordered. And that's very similar then to the position under the English common law, and that is reinforced through Article 63(3), which if you can establish that it would be the employer actually abusing its rights to require rectification, then again the law will not allow that. The question then of indirect or consequential losses. This is a slightly unusual one in a way, because indirect or consequential losses are not recoverable under Qatari law. So insofar as you have wording in your contract, and I'll come on to the FIDIC clause 17.6 that excludes consequential losses, then really that sort of clause on one level doesn't actually add anything to the protection to a party, because consequential losses aren't recoverable. However, what it really does bring into question in Qatar is, but if you've got these ideas of consequential damages in your head and you're thinking that actually, well, that's loss of profit, remember that those sorts of losses are actually recoverable under the general law. So you do have to be very specific about what it is that you are actually excluding for the purposes of making sure that it properly reflects the bargain that you think that you have come to with the other party. So conclusions on damages before I move on to limits on liabilities. It really is obviously shared themes and issues wherever you are, whatever is the law of the contract and whoever are the parties. However, and this is a point that you have to take on board, whichever jurisdiction you're working in, it's that you may be using the words, and especially if English isn't necessarily your first language, and you're using concepts which are legal concepts that are coming from a common law background, you need to be very, very careful about what you really mean. Now, as a lawyer, we as lawyers, we can always think up an argument for you after the event, but the advice is always certainty is better. And that's what I mean by really understanding what is the bargain that you have struck. And I repeat that final point there. The law, depending upon the law that is the governing law of your contract, it can change the risks in terms of what you understand. So then I turn to limits on liability, and I've set out there in it all of its detail the limits on liability. So just to pick up on those elements which are in bold, and then add a little bit of detail. So and obviously this clause is used very, very frequently in Qatar. So neither party, so it's not one of those which is only against the contractor. So you won't be liable for loss of use of works, loss of profit, loss of any contract, or for any indirect or consequential loss or damage. So the important part of that, of course, is spelling out the loss of use of the works, loss of profit, or loss of any contract, because potentially in Qatar, indirect or consequential loss is no additional protection whatsoever. The next point to make so in connection with the contract, and then remember that there are some very significant carve-outs from the benefit of that initial paragraph. One is termination. So if your contract is terminated, the protection isn't there. And I return to the point about indemnities. If you've got a very wide indemnity clause, or you've used the word indemnity and you leave the word indemnity in your exclusion of or limit of liability clause, then the indemnities are carved out and won't be subject to the cap. The second paragraph obviously relates to financial liability, and this one is only in favor of the contractor. Again, there are some fairly standard carve-outs from that, but the purpose, of course, is that it is not to exceed the sum. But then there are these further carve-outs, which is where there is fraud, deliberate default, or reckless misconduct, then both limbs, both the first paragraph and the second paragraph, won't apply. Now, it came up for us quite recently in a contract where a party was refusing to pay. And the contractor client decided that it was going to terminate. And so you're then left with a situation where, in all likelihood, because the decision not to pay was a deliberate default, the monies were, some monies at any rate, were definitely owed, then the employer was depriving itself of the protection of this FIDIC limitation of liability clause. So, a Qatar perspective, and I'm near to the end of my slides here, just in relation to two aspects. The first is, are clauses like the FIDIC clause enforceable? And the answer is yes. Contractually agreed limits or exclusions of liability are effective, although under Qatar law, the exceptions will apply, similar ones, but they're not. It's not quite the same. Gross negligence and fraud. It's not. It doesn't include this deliberate default excuse. And then, just for completeness, in relation to tortious acts, which aren't necessarily always going to be relevant in the context of a contract, that you cannot exclude liability for tortious acts through contract drafting. And then an often touched upon issue is the enforceability of liquidated damages clauses in a Qatar context. And the first point again is that, generally speaking, liquidated damages will be enforceable as a cap, but there are these two exceptions: fraud and gross mistake. There is the potential, unlike in the common law situation, for the liquidated damages figures to be reduced, but that then obviously will require evidence from the other party relating to what the contribution by the employer has been in respect of the damage. And then finally, and this is again an often raised question, which is where there has actually been no damages suffered, or where the claimed amount of liquidated damages is actually exaggerated, then there is the possibility for reduction in those circumstances as well, and this can't be excluded. Again, contrasting it with the common law position, the whole idea of liquidated damages in the common law context is that it's a bargain between the parties, where as long as there has been, and it's a slightly different test these days, but broadly speaking, as long as there's been some attempt to assess what those liquidated damages should be, and it's not clearly a penalty, then usually they will be enforced, irrespective of whether that results in some sort of windfall for the employer. So I now hand over to Khushboo, who's going to be talking about defective works and limitation periods.
Thank you, Andrew, and good morning, good afternoon to all of you tuning in. So today I thought I would speak about defective works because it's something that comes up in a lot of our construction arbitration cases that we see. And they occur quite frequently in construction projects, as some of you may know. The most common types of defective works that we see relate to waterproofing issues. So those that cause water ingress, cracks that appear in plasterworks due to poor installation methods of concrete boards, for instance, or poor workmanship of stones and marbling tiles. And it's typical for there to be long and voluminous correspondence back and forth between the engineer, the contractor, sometimes the project manager and employer as well, on these types of issues. So let's just maybe go on a little bit about what defective works are. Could we get the next slide, please, Andrew?
Now, Khushboo, we've got some technical hitch because I'm not able to move the slides on for some reason. If you could carry on speaking while I try and sort this out.
Yeah, no problem. I suppose this ties into what I was speaking about, defective works in PowerPoint slides, defective works in construction projects. But anyway, moving on. Defects are actually a breach of legal obligations. There we go. So it's the obligation of the contractor to deliver works in a proper manner and in accordance with the contractual terms in line with the contractual specifications and definitions of the contractor's scope of works. Sometimes non-conformance with specifications can also be considered defective works. If the works for that particular piece of project or that particular piece of flooring are not fit for its purpose. And this is obviously subjective in nature. So if a basement in a hospital project was intended to be a storage rooms for vaccines, for instance, it needs particular temperatures and structural appearance. It can't be used as a basement car park. So it's going to be obviously a defective work there if it's not going to be fit for use. Not all non-conformance may be considered a contractor's risk, and that's something to bear in mind. Where there's poor design, for instance, it does depend on the risks undertaken by each party in the contract. Poor manufactured work products, those would usually constitute defective works from what we see. Same for poor workmanship or installation works and poor maintenance works. Where there's external events, works caused by other subcontractors or contractors that cause damages and defects, for instance, cabling trays or cabling works, those would also frequently constitute defective works. Can we get the next slide? So the next question that usually arises is the discovery of defective works. And when we come to discovering defective works, there are two different categories that's worth sort of deliberating on. It's apparent defects and latent defects. So when the issue that frequently arises is what is the timing of discovering these apparent defects and their consequences. Now, the approval or acceptance of work by the employer doesn't necessarily bar a subsequent claim for defective works. It is obviously subject to the relevant contractual provisions in play and the relevant law. So under Qatari law, the contractor is not going to be liable for any apparent defects in the works or non-conformance with the requirements of the contracts once the work has been handed over or deemed to have been handed over and then accepted by the employer. Apparent defects are usually easily visible. They are detectable through routine checks, and that's sort of the logic behind why a contractor shouldn't be liable for apparent defects. Taking over the works may be deemed acceptance in certain circumstances. So typically this is examined on the contractual provisions in play on a case-by-case basis. So if there's nothing specific on this in a contract on apparent defects, then usually the answer to every contractor would be that they're not going to be liable if it's a routine defect that could be easily inspected by the employer during the handing over of the works. Can we get the next slide, please? So when we come to latent defects, though, the answer is a little bit different. Latent defects are those that cannot be discovered by reasonable and customary observation or inspections, and different consequences would hence apply. So under Qatari law, where there are defects or breaches that are considered to be latent in nature, and the employer only detects these after taking over the works, then the employer may notify the contractor of this and require the contractor to perform remedial works in line with industry norms and practices. If the employer remains silent in these circumstances, this will be deemed to constitute acceptance of the defect, subject to obviously terms of the party's contract. And the timing of this is constantly something we see that's in dispute between the parties on how long after taking over the works should the employer then notify the contractor of these defects. If it's sometimes seen as too long, the contractor's argument is always that it's deemed to be constituted acceptance on the part of the employer. But now there's something that's worth bearing in mind is the senior liability. And I see someone just mentioned that, and that was just my next point. So when it comes to decennial liability, this is a mandatory provision under Qatari law that would apply regardless of the party's contractual position. And in the next slide, I speak a little bit more about that. So decennial liability is essentially defects that threaten to compromise the structural integrity of a building or a fixed installation that results in a total or partial collapse of the structural integrity. And under Qatari law, there's a strict liability on the contractor when it comes to decennial liability. It is a mandatory provision, so you cannot change it even though parties want to contract out of it, it's not possible. It would apply regardless of the party's contract. And it's imposed on the contractor as well as the engineer with respect to any collapse or defects related to the integrity of the building. And again, we see this contested a lot in the cases that we see in disputes. What constitutes integrity of the building, what constitutes structural integrity, especially, it's something that we always get experts to assist us with. Sometimes it's fairly uncontroversial. It's something related to design defects, to workmanship that is so detrimental to the building's structure. Sometimes it could be borderline cases. So it really depends on the case. The liability lasts for 10 years from the date of the handover. And that's again codified in the Qatari Law Civil Code. So the contractor is liable for defects related to workmanship, but not for defective design, unless they could have been discovered by him in accordance with his professional practices and his duties. And that's something, that's a nuance that's worth bearing in mind, because again, the distinction for this can be sometimes controversial and sometimes uncontroversial. So it really depends. To the extent that defective design can be discovered, we usually get, again, expert evidence to help us with this, because it really goes back to what happened in the project from years ago when they received the designs and the extent to which they progress the shop drawings, if it's a design and build contract. So given this, the contractor has the obligation to refuse the execution and to warn the employer about the defective design when he receives it and he sees some sort of anomalies with the design. If not, the contractor will be jointly liable with the engineer for any damages that are ultimately claimed by the employer. So let's move on now to defects notification period, because that's also another key topic when it comes to defective works. This is defects notification periods usually in a contract, and this in all FIDIC Red Book contract. Typically it's 1 year. It can sometimes be extended to 2 years where works cannot be used for the purposes they were intended to due to these defects. And the contractor has the right to remedy these defects with reasonable notice. Now, Andrew touched on this earlier with respect to specific performance, so obliging the contractor to remedy its defect or damages in its works. If the contractor fails to remedy or the defect or damages, what then happens in a typical FIDIC Red Book contract is that there are 3 options usually available to the contractor. Number 1, he can carry out the remedial works at the contractor's cost. And these are reasonably incurred costs to be paid to the employer. What is reasonably incurred costs is frequently debated because remedial works can really vary depending on the methods used to remedy these works. The second option is to agree to determine a reasonable reduction in the contract price. We don't see this as often because usually when it comes to the stage of a dispute, parties are contesting this quite heavily. So it's there in the FIDIC Red Book if it's not varied in the contract, but we don't really see this option being used in practice as much. The third option is to terminate the contract if the defect or damage deprives the employer substantially of the whole benefits of the works or any major part. Now, there's a high threshold for this, obviously, and because of that, again, the burden of proof for an employer is quite high for it to meet this threshold. If they do end up meeting it, then what they can actually recover is sums paid for the whole defective works, all the financing costs associated with this, the cost of dismantling the works, clearing the site, and returning plants and materials. So this is the third option, which we don't see as often, but because the threshold is so high, but once it's met, it's a remedy that employers would usually prefer, where there's defective works in play. So for DLP or DNP, usually inspection is key prior to the handover, obviously, and there's an approval process through this depending on where the project is based. There's also retention monies that need to be paid back to the contractor once the DLP is ended and they sign off on there being no defective works in the project. Now, the liability for defects is subsequently discovered after the DLP period is extinguished. That's possible. So that means that when an employer discovers something after the DLP period, what this means is that usually the contractor is off the hook, with the exception for decennial liability. So where there's something that is so grave and really affects the structural integrity of the building, then they're not going to be off the hook for that because that's a mandatory provision that would apply regardless. So can we get the next slide, please? Now, what's recoverable where there are defective works? Again, Qatari law is quite clear on what can be recovered. So the law says that compensation that can be recovered from a contractor's actual cost that's incurred, the loss of profit, provided that such loss and damage are a natural consequence. The employer's entitlement to its loss of profits is dependent on establishing that the losses and damages were natural consequences of the breach. And that's usually the lawyer's job to make sure that the causal link is there and it's quite clearly established in disputes. Absent fraud or gross negligence, a party may only be liable to pay compensation for damages that was foreseeable. And that's usually the threshold, whether the damages were foreseeable at the time of entering into the contract. Even if the lost profits are exceptionally high, they would be recoverable as long as they are foreseeable and as long as they are direct. So again, these are key when it comes to recovering damages from the contractor. Can we get the next slide, please? So what are some practical considerations when it comes to defective works? So obviously notification of defects, that's key. The contractor always has the right to inspect and or remedy the work. So he must be given the first right to come in, to have a look at works and be given the opportunity to remedy them. Usually when it comes to a dispute, usually in arbitration, we always tell the contractor to maintain detailed records of the NCR that happened. So these would be site observation reports where the HSE officers then signs the report saying there's been a non-conformance with the specs, with the designs or with any workmanship. The site surveys, test results, samples, photographs, all of these are really key documents that I then use as evidence in an arbitration. We also tell the contractor to get third-party inspection reports as much as possible, to the extent they can. Sometimes they get status quo reports, so they go to the local courts and ask the local courts to appoint an engineer to then come in to inspect the works and do a status quo report, which sorts of details the defective works in play at that point of time. So that sometimes becomes really good evidence for us in an arbitration. If they can get some people to come in to do root cause analysis, that's always helpful. And remedial documents, again, so what are the method statements used to remedy the works, the basis for pricing the rectification, cost records or proposals identifying the rectification works, all of these are really key. When it comes to residential projects that are sold or rented out, any complaints of defective works that are always key. In the case that we had, we asked the employers to document all the complaints either through a telephone conversation or through emails on any leakages that happen, cracks that happen in buildings that were rented out and sold. And those become really good evidence in the arbitration for our counterclaim for loss of profit and for the cost that we had to incur to remedy the defective works. So moving on to the next sort of subtopic, contractual limitation periods. Now, limitation periods can be, we see this in contracts or in statutes. And in a sense, they are a form of limitation of liability in the period for which a contractor can be liable for a breach of obligation. So when it comes to defects liability period, usually it's for a year from the date of practical completion, which is the date of taking over certificates. In warranty periods, we see this in engineering contracts, usually 1 to 5 years. They can be extendable, but rarely over 5 years. So that's what we usually see. And there are very specific obligations regarding repair and replacing these defective works. They're often expressed as exclusive remedies, so that's something to bear in mind. Once these sort of limitation periods are over, then there's a final reconciliation that's done where LDs that may be due are deducted, any damages are reconciled, and the final payment is then done to the contractor. So liability usually continues for the contractor until the end of the statutory limitation period. For engineering contracts, it's a little bit different. The contractor's liability ends then, except for when it comes to latent defects, that's when the liability usually will continue onwards. The next slide, please. So limitation periods in Qatar. I mean, as some of you may know, statutory limitation periods are prescribed as a matter of Qatari law and public policy, so they cannot be varied by contract. And usually it's 15 years from the date when the right to claim crystallizes. Unless it's a commercial entity, then that year is reduced to 10 years. Where there are latent defects, strict liabilities imposed on the contractor and or the engineer for a period of 10 years from the date that the works are handed over. And that again cannot be modified or varied by contract. And so as you all know, it's not possible to agree on limitation periods other than those specified by the law. I think now I'm going to hand it over to Aiman to speak a little bit about the Qatar compensation scheme, and then we'll come back for any questions.
Okay, thanks, Khushboo. And yeah, we've had a few questions as we've been going along, so we'll come back to those after Aiman's done his presentation on the Qatar compensation scheme.
Yeah,
over to you.
Thanks very much, Khushboo. Good morning and good afternoon to everyone. So this part of the presentation really focuses on a new development that's taken place, and it relates to a new compensation scheme that Ashghal plans to deliver to its contractors. And I thought this part of the presentation could sort of focus on this compensation scheme and the mechanism behind this compensation scheme. So the real background to the compensation scheme is the COVID pandemic and some of the costs incurred by the contractors, as well as a recent minimum wage law that became effective in March of 2021. The new minimum wage law in Qatar sets a new minimum wage of 1,000 Qatari riyals for all workers, and also sets an additional allowances for 500 and 300 riyal that relate to accommodation costs, as well as food and beverage expenses. So these two components really inflated the price for various contractors working in the region, and this sort of resulted in a letter to the chairman of the Council of Ministers from 18 companies. This letter was sent out around the 5th of October, and the letter relied on Article 17 of the Qatari Civil Code. Article 171 states that the contract is binding between the parties, but lays down certain exceptions when obligations are particularly onerous to meet, and thereby the court can reduce such obligations. So these contractors really relied on this particular provision of the Civil Code, as well as change in law provisions addressed by the law, and similar approaches taken in the region, namely in Saudi Arabia and Egypt. Now, what the contractors requested for was an increase in the value of the contracts because of the minimum wage law and the COVID pandemic and increase in costs. So they request for a 4.5 increase in their contracts and additional compensation from the minimum wage law, and as well as additional compensation based on evidence, that evidence being monthly statements of the work carried out. So the compensation scheme flows from Qatar's Public Works Authority, as I previously mentioned, which is Ashghal. And back in January 2022, this year, they came out with a presentation, and I should talk about some of these key components of this presentation. But the presentation is basically a non-contractual process for compensation of these issues that I touched upon. So the presentation really allows compensation for three main issues. That is the minimum wage, circumstances beyond the party's control, as well as increase in price of materials. So taking the first issue, this slide really touches upon the mechanism for the increase in the minimum wage. And it says that there shall be two phases in doling out such a compensation. And the first phase sort of really rests upon the average number of direct or outsourced manpower affected from this, affected from COVID implications. And it says that this first phase will basically revolve around an average number, which is an average number of the manpower, and it shall focus on 50% of the compensation of the affected workers. And it lays down certain additional compensations for these workers, namely being compensation of 300 riyal for those workers who are receiving a salary less than the minimum wage, and a compensation of 100 riyal for food provisions. And thereafter, in phase two sort of moves beyond the average number and focuses on more documents and more of a particularized account. And in this particular phase, we move beyond the average numbers and we look at actual supporting documents. And at phase two, parties are supposed to put in documents that prove their actual claim. And based on some of the numbers that we discussed earlier, phase two will dole out compensation resulting from the minimum wage decision. Thereafter, we also have compensation for circumstances beyond the control of contracting parties. And the key issues to really focus here are probably the reduced productivity during the COVID pandemic, as well as increase in transportation cost. So we have 7 real key issues to focus on. And at the end, the total amount per worker amounts to 762 Riyal as compensation. And the real key point to focus here is the timeline. And this compensation is before April 2020 for projects that commenced before April 2020 and had a completion date on 31 December 2021 or beyond. We have another mechanism on the same issue, and that being circumstances beyond the control of contracting parties. But here, the difference out here is really the dates, and this increased compensation focuses on projects with a commencement date of Jan 2021 and a completion date of 31 December 2021. However, what we notice here is that the compensation really remains the same, and the recommended amount per worker is around an additional 762 Qatari Riyal per worker. So the mechanism is similar to the first issue, in which you have an average number in the first phase, and the compensation given out to contractors is 50% of this average number that falls between the beginning of April 2020 and until the end of December 2021. And in phase one, the compensation is, as you mentioned, 762 per man force on the project. So this is an average number without really focusing on the true number, and the true and actual number sort of comes into play in phase two, where contractors are supposed to submit particularized accounts and sufficient documentation that shows the direct costs that result from the man force and increase costs on the manpower. And this is much like the first issue, but the only difference here is that you have another phase three, where Ashghal is contemplating EOT periods along with sort of some prolongation costs associated with these extension of times on the project. However, what we learn is that this is under contemplation and phase three has not been implemented so far. So then we move on to another issue, which is compensation for an increase in the price of materials and shipment costs. So generally under Qatari law, the Qatari law states that that contractors will not be awarded an increase in the contract price due to changes in materials, unless there is a specific mention under Qatari law. And in fact, even the FIDIC documents have a template that lays down increases due to price inflation and increases due to shipment costs. So the cost of materials, so that compensation would be paid to contractors based on proof of 2 issues, and these 2 issues have to be proven simultaneously. One is that the cost of materials or cost of shipment is higher than the market price, higher than 20% of the market price at the closing of tender. And the second being that this has resulted in increase in 2% of the contract price. So these two components or these two limbs have to be met together to avail of the compensation process for global inflation and global inflation in materials and shipment costs. So these are the three main issues that Ashghal is contemplating at the moment. And it seems that this is a work in progress, and compensation, as per our information, has not been really delivered to these contractors. However, Ashghal is considering delivering compensation on these three issues, and it, as I said, is more so a work in progress issue at the moment.
Thanks, Aiman. Really useful. And obviously, this is a thing which is between Ashghal and its contractors. It's not wider than that, is it? And it still leaves the question open about what about the subcontractors?
That's correct.
Yeah. Okay, so we've got about 10, 15 minutes, and I'll just go on to some questions. Let me see. It's always quite difficult to try and make sure I turn this into a question that is probably not too difficult, but it may be an interpretation of what's been written. So Khushboo, there's a question related. What the difference between apparent and latent defects? Do you want to pick up on that? You know,
yeah,
how
no,
are they
sure.
treated
Yeah.
differently in the contract?
And then someone did ask if apparent defect is caused by not complying with the contract docs or drawings.
Yes.
Yeah, I mean, and that's the question that really goes into the essence of what's an apparent defect, what's a latent defect, and we see this all the time. So to answer the question that's on display on the screen, if an apparent defect is caused by not complying with the contract documents or drawings, it's still an apparent defect, and the same consequences would apply. In fact, most of the time we see when we deal with apparent defects, it's actually caused by this very purpose, where the contractor doesn't comply with the proper contractual specs or the proper tender clarifications as he ought to have. Some examples of apparent defects would be, say, if there's issues with the facading works, external works, something on the paint works, or on the veneer, for instance. In previous examples, we had where there were cracks or chips on the marble or stone tiling work. So that was constituted as apparent defects because it would have been discovered quite easily if the employer had tuned his mind to them during the inspection. So where there's discoloring of marble or stone tiling work, that's another example. Latent defects it's a little bit more, it's a tricky because they can relate to designs, they can relate to workmanships, they can relate to building structures. So it obviously just there needs to be something more than just a routine inspection. There needs to be HSE officers with you. There need to be proper engineers to inspect the buildings. So that's when you wouldn't know if you just do a routine inspection. And that's sort of it's the way we differentiate between the two. If it's something you could have walked around, you could have spotted it through a naked eye, then that's obviously an apparent defect. And if something that you couldn't have detected through a routine walk around or site visit, then that's a latent defect. So I hope that answers the question on that.
And then there's a number of questions that have come in relation to limits on liability, and I won't deal with them specifically, but I'll just try to answer broadly. There is the FIDIC clause that we've referred to. There's no reason, certainly in Qatar law, why you couldn't use a different limitation of liability clause, and why you couldn't use the FIDIC clause as a starting point and then expand upon it and add in other things which would cap the both or one of the parties' liability. There's then something that's been raised in relation to a question of the word production. And I think there may have been a bit of confusion there. So when you're referring to loss of production, that's usually in respect of some sort of facility where you've got raw materials coming in one end and you've got a product coming out the other. So that's actually in relation to the facility and damages which, or limitation of liability clauses which exclude loss of production in that way. Where you're talking about productivity, more often that's probably dealing with the contractor's ability to perform the works, and where there is a claim in respect of loss of productivity and the job's taken longer and is more expensive. It would be unusual to refer to loss of productivity from the contractor perspective in a limitation of liability clause. But you do need to be careful about which word you're using. And of course, it does really depend on what is the bargain that the parties have reached. Is the intention to exclude either or both of loss of production in the employer sense and loss of productivity in a contractor sense? Another point asked or raised is just in relation to the proof of loss, and I think it's something that you picked up on, Khushboo. I mean, all legal systems will require a level of evidence to support the claims. But one thing that's come up for us recently, actually it was in relation to an issue in Kuwait, but it's applicable in Qatar as well, and that is whether or not these formulas that have been generated out of the sort of common law tradition, like the Hudson formula, the Emden formula, I'm never too sure how to pronounce it, I think it's Eichle formula, whether they are accepted in GCC countries. And my own view is that, I mean, there's no reason why you shouldn't try it. However, all of those formulas, and some are better than others, are necessarily attempting to put a figure on overhead and profit, whereas they're not actually proving what the loss is. So in my view, it's highly unlikely that in Qatar law, and indeed most GCC countries, that the use of those formula would be successful in a damages claim. Let me just see if there's anything else which
Maybe a related question I can answer, Andrew, is loss of profit claims resulting from defective works. Someone asked if could there be loss of profit claims where there are defective works, and you touched on this slightly, but I'll just expand. And that's actually very possible. So when it comes to defective works, we do have claims for loss of revenue. So that's quite typical and common. Loss of profit claims are obviously difficult to prove. They require evidence that the employer had the opportunity to tender into a different project, but couldn't because their funds were tied up. So it sort of relates to the fact that they had a loss of revenue because of the defective works, then couldn't use these funds on a different project. So it's possible, but again, the burden of proof is so high that you need to back it up, lots of evidence, documentary proof, LOAs from different tender projects. So all of it needs to be substantiated to actually make a loss of profit claim when it comes to defective works.
Yeah. Okay, so I think we're finished. Thank you very much for everybody who's attended. This was really sort of the last in our series before the summer break in relation to Qatar, and generally the Tamimi construction team's webinars. But we hope to see you again in the later on in the year, probably sometime back end of August, beginning of September. And certainly our intention is to circulate the slides to all of those who've attended. And certainly if any of you have any further questions which you would like to ask, please feel free to follow up with us. So once again, thank you very much, and enjoy the rest of your day.
Thank you. Bye.
Bye.
Thank you.